Most families think they've got their estate planning sorted out when they write a will. But here's the harsh reality. They're setting their loved ones up for months of legal headaches, thousands in unnecessary fees, and family drama that could tear relationships apart forever. I've seen it happen countless times, and today I'm going to show you exactly why the choice between a will and a trust could be the difference between leaving your family a gift or leaving them a nightmare. Look, I get it. When most people think about estate planning, they immediately jump to wills because that's what everyone talks about. Your parents probably had a will, your grandparents had a will, and every movie you've ever watched shows some dramatic will reading scene. But here's what nobody tells you. Wills are actually one of the worst ways to transfer wealth to your family. Now, before you think I'm completely crazy, let me explain exactly what I mean. I'm going to break down the real differences between wills and trusts in a way that actually makes sense, without all the legal jargon that usually makes your eyes glaze over. By the end of this video, you'll understand why most wealthy families use trusts, and more importantly, how you can protect your family the same way. But first, let me share a story that perfectly illustrates why this matters so much. Meet a woman named Sarah. Her dad had passed away suddenly, leaving behind a house, some investments, and what everyone thought was a simple will. Sarah assumed everything would be straightforward. After all, her father had been organized, he'd written everything down clearly, and the will seemed to cover all the basics. But what happened next was a complete disaster. The will had to go through probate court, which meant every single asset became public record. Suddenly, distant relatives she hadn't spoken to in years started coming out of the woodwork, claiming they deserved a piece of the inheritance. The legal fees started piling up. First, it was a few $100s here and there. Then, it became thousands. The house couldn't be sold because it was tied up in probate. The investment accounts were frozen. And Sarah found herself spending every weekend dealing with lawyers, court filings, and family members who were suddenly very interested in her father's money. 18 months and $23,000 in legal fees later, Sarah finally received what should have been hers from the beginning. But by then, the stress had taken its toll. Her relationship with her brother had completely fallen apart over disagreements about the estate. Her mother was devastated by all the family conflict. Sarah wouldn't wish that experience on her worst enemy. The crazy part? All of this could have been completely avoided if her father had used a trust instead of a will. While Sarah was dealing with lawyers and court dates, families with trusts were quietly transferring assets to their loved ones without any of that drama. So, what exactly is the difference? And why does it matter so much? Most people think a will and a trust do the same thing, just with different paperwork. That's like saying a bicycle and a Ferrari both get you from point A to point B. Technically true, but you're missing the entire picture. Here's the thing that blows most people's minds. A will doesn't actually avoid probate court. In fact, having a will guarantees you'll go through probate. It's like having a roadmap that leads you straight into the most expensive, time-consuming legal process possible. When you die with a will, here's what actually happens. Your will becomes a public document that gets filed with the court. Every asset you own, every debt you owe, and every person who benefits from your estate becomes public information that anyone can access. Your nosy neighbor, that ex-business partner you had a falling out with, or even complete strangers can walk into the courthouse and read all about your family's private financial business. But that's just the beginning of the problems. Probate court moves at the speed of molasses on a cold day. We're talking months, often years, before your family can access the money and property you intended to leave them. During this entire time, your assets are basically frozen. Your family can't sell the house, can't access investment accounts, and can't make any major financial decisions without court approval. And let's talk about the costs, because this is where it gets really painful. Probate fees typically run between 3 and 7% of your total estate value. So, if you're leaving behind a $400,000 house and some investments, your family could be looking at $20,000 or more in fees before they see a single penny. That's money that should be going to your kids or grandkids, but instead, it's padding some lawyer's bank account. Now, here's where trusts completely change the game. Think of a trust as a special container that holds your assets while you're alive and then seamlessly transfers them to your beneficiaries when you're gone. No court involvement, no public records, no waiting periods, and dramatically lower costs. When you create a trust, you're essentially creating a separate legal entity that owns your assets. You remain in complete control as the trustee while you're alive, so nothing changes in your day-to-day life. You can still buy, sell, and manage everything exactly like you always have. But when you pass away, a successor trustee you've chosen steps in and distributes everything according to your wishes, usually within a matter of weeks. Think about it this way. You wouldn't leave your family a gift wrapped in barbed wire, so why leave them an inheritance wrapped in legal red tape? The choice between a will and a trust isn't just about paperwork. It's about whether you want to leave your loved ones a blessing or a burden. Don't make the same mistake Sarah's father made. Your family deserves better than months of court battles and thousands in unnecessary fees when you could give them the gift of a smooth, private transfer that protects their relationships and their inheritance.